Hi folks, welcome to a thrilling new episode of Cyber Narratives. I'm your host, Mathieu, Cyber Dr. Peto, and today we are welcoming on the podcast Rohan Massey. Rohan leads the legal practice of Ropes and Gray for the part of data, privacy, and cybersecurity here in London. He knows a lot about the legal system and particularly everything about privacy, data, and cybersecurity. Everything that we care about. Let's see what he has to say. Rohan, welcome to the podcast.
Matt, thank you very much. It's good to be here.
Wonderful. Great, Rohan. So can you, just to introduce yourself a bit, can you tell us how you got in the world of, let's say, cybersecurity, privacy, and data within the legal system, within the law?
Sure. So I qualified as a lawyer in the UK about 25 years ago, just really when the internet was coming out and pre the dot-com boom. So I started off as an IP and technology lawyer, working with, the early Data Protection Act, the 1994 and 1998 Act in the UK, drafting privacy notices that nobody ever read on the dial-up internet. Then sort of my practice progressed, and really from 2007, 2008, the world changed. So 2008, we had the financial crisis and transactions slowed down. Mm-hmm. But the year before that, there'd been a little invention brought onto the market by a company in the US called Apple. It was the iPhone. Mm-hmm. And that was a game changer. So sort of 2008 onwards, the idea of data traveling with us, always on connectivity, the use of the smartphone, saw this whole area develop massively. And that's really where I started advising more, not just on the regulatory side, drafting privacy notices that still nobody read, but also looking at cybersecurity breaches, response to those, regulatory enforcement, and so many other areas of data that we've now seen grow as we move into a digital society.
Mm-hmm. And how did cybersecurity come up for you?
How did it come up? Well, the most important one really was through the sort of GDPR and data protection, which is, the data has to be held with appropriate security, both technically and with organizational measures. So looking at that, looking at how we protect data, the importance of protecting and keeping data secure is really where I came into this. And now looking at the EU, there's 100 different pieces of legislation approximately that are working in the digital space, all of which require some form of security for the data that they're trying to protect. And those elements of complexity and enforcement are really how I got into this.
Got it. Okay. Wow. Makes sense. What a nice, logical way of managing things. Rohan, so about, I'd like to understand, and the listeners like to understand a bit more about what a lawyer in your position does. Can you walk us through, let's say, a recent example of how you've helped a customer of yours?
I certainly can. So how do I help people who've suffered from a cyber incident or a cyber breach? Well, usually I will get a frantic phone call, first of all. It could be, we've been locked out of our systems because we've had a ransomware attack, or we found out that data has been transferred, externally or stolen by a third party. What do we do? And at that point, there'll be a number of different parties involved with the client. So the board will usually be involved. The IT function will be involved. The legal function will be involved. If they've got crisis communications teams will be involved. And what my job is to do is to sort of look at the regulatory aspects of what's going on, but also to advise as a trusted advisor. To sort of say, look, for you, I hope this is your first rodeo, but for me, it's not. Mm-hmm. Let's talk about what we'll have to do. And so then we'll break it down. The first 72 hours of any breach are going to be critical when you found out. So you'll have taking the systems offline and making sure you're trying to contain the issue. Then we will start investigations looking at, what caused the issue and how it can be remediated. And then we'll look at remediation slowly. And there are so many different elements of that we have to draw together very quickly. And I will assist in doing that.
Okay. So we've talked a lot about communication, response, and, the technical aspect. But precisely, what would a lawyer do in such situations?
Okay, so if we look purely at the regulatory piece, there are a number of pieces of legislation. Again, let's look at the EU. You may have personal data, so you've got the GDPR. You could have, the client could be in a critical infrastructure space, so governed by the requirements of the NIST directive and the Network Information Security legislation. It could be international, so you could be looking at obligations under foreign laws, so US laws, international laws in Asia, or etc. So you're looking at all of those pieces and trying to understand what the problem is and where we'll have to report issues. Now, most jurisdictions now have some form of regulatory requirement for notifying if there has been an incident, a data incident. Now, that may be just because you've been attacked, or it may be because data has been exfiltrated, or it may be that personal data has been exfiltrated. And so you have to assess what information has been attacked or exfiltrated, what obligations the organization is under in which jurisdictions to notify, whether it's to notify regulators or in some instances to tell individuals who've been affected. And then you'll have to work out what the time frame is, because a lot of these laws have specific time frames by which you have to notify. And so it's working through that whole matrix of where the incident is, who's been affected, what's been affected, what notifications are required, what is the time frame for those notifications, and then prioritizing those. So you're doing that as a lawyer at the same time as lots of other elements are going on. Forensics are continuing to discover what the extent of the issue is. Now, some of these timeframes are very tight. Under the GDPR, we have 72 hours from the point of awareness. Now, if you know you've had an attack and some personal data has gone, 2 hours may not be enough time to actually understand the full scope of the breach as you're trying to investigate it. So it's trying to manage what information will be shared to meet your regulatory requirements and the time frame for doing that, and then what information you'll have to keep updating later as you find more and more going through the system.
I see. And I was just going to ask about this, actually. How do you deal with all this uncertainty? Because, things keep popping up in cybersecurity. It's never done, and especially in cyber incident. So how do you keep up with this uncertainty of information, constant flow?
Yeah, I mean, one of the great things, and I think regulators, especially in Europe now, are very switched on to this, which is kind of layering of information. So I'll keep using the GDPR as a very good example, only because it has a very specific time frame and requirement in it. So it's got 72 hours. So as long as we notify the relevant regulator within 72 hours there's been a personal data breach, we can just say there's been a breach. Here's the information that we have so far, and we will update you going forward. Now, in doing that, the customer has, or the organization has met its compliance requirement for notification. It's also then bought some time, because after that, there is no specific legislative time frame for updating. Some regulators will say we want to be updated on a frequent basis. Some will say, actually, you've now got another 30 days. But you've bought yourself time to work through and really understand what the situation is without providing a huge amount of detail to the regulator. And that can be helpful because, we have seen in the past, and I think that in the UK, in the BA breach a few years ago, when there was a rather large fine issued, one of the issues in the report is the information that was given in the first notification was actually changed later as the investigation proceeded and progressed and more information was unearthed. They changed the position of what they'd recorded in the first report. And the regulator sort of took umbrage with that. And I think that's it was a rather unfair position, I think, because, as I say, people are still trying to work things out right at the beginning. But what it has done now is meant, well, the less you say at the very beginning may be helpful, because it gives you more chance to be certain, or as certain as you can be, as you move through and do reporting later in the investigation to ensure that it's accurate.
Okay, so if I understand correctly, then the biggest priority for someone who just suffered a cyber attack is to report it within this deadline and then keep updated afterwards.
Yeah, I think the biggest priority for anybody suffering a cyber attack that involves personal data is to ensure that they've met their notification requirement within the first 72 hours. Right? Regulators are clear on that. The Irish regulator has already said, if you look at the legislation, there is a 72-hour requirement, and we will want you to meet that requirement. Even if you do not have a lot of information, you should still notify us within those 72 hours. So I do think that's got to be of primary importance if there has been a personal data breach.
I see. Yeah, makes sense. We're talking a lot about GDPR, but usually we see big companies at least making the headline. We've seen Meta, we've seen Google hitting these headlines for GDPR non-compliance. But how are these rules actually applied within the realm of cybersecurity and data breaches? Do we really see, big impacts going for even small businesses? Is this something that's being sanctioned by regulators?
I think it is. And I think we're seeing an increasing amount of the sanction enforcement by regulators. So when we look at what regulators are enforcing in relation to cyber breaches, I think it's important to remember there's been a period of education, and there's now been a period of maturity and understanding, so that from the biggest organizations right the way down, cybersecurity is critical. So if you're suffering a breach, whether it's you, whether it's somebody in your supply chain, there is a risk there. We've seen at least 2 UK breaches result in multi-million pound fines. So there's the Starwood case, and there was the BA case. We've seen others resulting not such significant fines, but certainly material fines. And in fact, even yesterday, the ICO in the UK put out its first provisional fine to a processor, which is a fine of £6 million in relation to a breach because there was no use of multi-factor authentication that led to a breach involving approximately 80,000 personal health records of individuals. So where there is a significant impact on individuals and there is an issue that could have been addressed and should have been redressed, such as the use of multi-factor authentication because of the contextual importance of the data being protected, then regulators are focused on this. And in the US, it's the same. In the US, we've seen much more significant fines in relation to cybersecurity breaches. I mean, I think they're slightly more developed in their sanction landscape over there. They've had notification requirements and penalties going back to the early 2000s, whereas really in Europe, we only started bringing these in sort of 2018 onwards, and we're seeing that development now. So it is certainly something that regulators look at, and fines may not always be the best or the biggest sanction. There can be public censure, there can be corrective measures saying that you have to put in place certain security requirements going forward, etc. Now, a lot of companies will do that because there's nothing better to focus the attention of the executive than actually suffering a cyber attack and feeling the pinch of that crisis to say, oh, actually, maybe we do need to focus on security. Where we've been asked for budget in the past, we're now going to find that budget to make it available and make sure that we have remediated properly, because that is something the regulators will look at. What steps did you take in response to this attack? Not just how did this attack happen?
Yeah, that's a critical factor we're seeing today. You have to prove to regulators and to your customers, to your partners, that this won't likely happen again, or at least not to this extent. I want to follow up on the MFA part. You said the company got fined £6 million for lacking MFA. Was it just because there was a breach, or was it because they missed out on having an MFA measure that they didn't implement?
Yeah, I think it's worth just qualifying at this point. At the moment, because of the UK system, it is a provisional fine. In the press release that came out yesterday, the ICO is very clear that at the moment the company has not been found in default or in non-compliance, but it will now listen to representations from the company. But the ICO is minded to issue this £6 million fine. Just it's a quirk of the English system, and I just want to make that clear. But on that basis, the issue was, this is a service provider as a data processor. It is working with health records and sensitive category personal data. Therefore, the appropriate technical and organizational measures will be higher than were it just dealing, for example, with contact information. And on that basis, it would appear that multi-factor authentication, which is readily available and easily accessible as a technology, would be an appropriate measure for security in relation to that data set. The fact it wasn't being used is one of the questions sort of raised by the ICO as to why that was not being used, because it seems that would be an appropriate technological step now, looking at budgets, looking at state of the art, and looking at the volume and sensitivity of the data being protected.
One question, Rohan. We've seen that we need to implement MFA, but then, a lot of the time what I'm seeing, I used to be a salesperson in cybersecurity at CrowdStrike, actually, so software vendor. And what we noticed is that there was a lot of people that were buying antivirus to say they had antivirus, and they're not really buying the best technology or whatever's adapted to their needs. So is there a bit of backlash on this? If you buy really cheap MFA, for instance, could regulators say, hey, you bought MFA, but it's not really according to your standards? Or will they say, okay, MFA was there and it was ticking the box?
No. In relation to the use of appropriate technical organizational measures for security, I think that the days of box ticking are over. Regulators will want a clear rationale as to why steps were taken in your security program. So why did you implement a certain technology over another? What did you consider more than one technology? Was it purely budget driven? Did you actually consider the type and volume of data that you're trying to protect? All of those elements are critically important. And I think for anybody building a cybersecurity program these days, there needs to be clear documentation right the way through as to what you are doing and why. Right? And this goes not only to breach response, but it actually goes to the governance and accountability measures under most of the sort of cybersecurity and security related laws, because you will need to evidence to a regulator, not only at the point of investigation post incident, but were they to audit you or ask for, investigate you for any other reason, and there are lots of reasons they can do proactive audits, that you can say, yep, here's our program. This is why we've taken the steps we've taken. This is why we may not have taken some steps yet. Maybe it's budgetary, maybe it's, functionality, but we're planning to do. But it's critical that in dealing with sort of these issues that you I think document them and have a record of the rationale for why decisions are made. But I do think the idea of just sort of getting the cheapest box checking days are long gone.
Okay. That makes sense. I think documenting and explaining your rationale for different decisions is definitely a key trend in today's cybersecurity environment. I want to dive into something that you've mentioned earlier, which is the supply chain attacks. Now, for those listeners that don't know what a supply chain attack, it's when a third-party software gets attacked, and through this software, you get attacked. So, Rohan, how you've talked about those. Why is this becoming a trend, and how is that relevant to our conversation today?
So, why are supply chain attacks becoming more and more of an issue? I think it is because the threat actors see, two things. One, vulnerability, and two, volume of data. So vulnerability comes because a lot of the supply chain links have to be connected to the internet. So for example, if you're using an external payroll provider, there has to be some means of transfer to and from the payroll provider of the monthly payroll information. Therefore, the provider is likely to have some sort of open gate connectivity with the internet. This is exactly what we saw in the MOVEit attacks last year, right? So MOVEit was a file transfer system. It had obviously open connectivity with the internet, and that was the vulnerability, and in that case, a zero-day attack, but a vulnerability exploited by the threat actors. The other issue is the volume of data. If you are going to somebody in the supply chain, it's likely they may have more than one organization's information, which puts the greater the volume of information that a threat actor can get hold of, and the greater the sensitivity, the greater the leverage they may have if they're trying to undertake some form of extortion. So both of those elements, I think, are critical in understanding why supply chains are attacked.
And so from a legal standpoint, in this MOVEit example, who's ultimately liable for the data that might have been leaked through this supply chain attack?
Yeah, well, again, if we use personal data, because I think that's the easiest reference point here, and looking at the MOVEit attack, some of it was on payroll. So the controllers will be the organization whose employees' data is there. The payroll provider will be a processor for the most part. Now, under the GDPR, the buck stops with the controller, because it is the controller's obligation to ensure that the data is held with appropriate security. And that includes where the controller uses a third-party processor. So it should, in its contracting phase, be undertaking due diligence with processors, ensuring that they meet the security requirements. And there is, in fact, under Article 28 of the GDPR, a requirement to have in place a written agreement with a processor that does say it will meet those security requirements. So you may be able to offset liability contractually, but as a controller under the GDPR, it will rest with you. And that's why, and I sort of mentioned earlier, the UK's ICO's fine against a processor, the first fine provisionally being issued earlier this week, is important. because it goes to show that not even though the controller is ultimately responsible, regulators can go after processes where there have been breaches in the chain, and this was one of those circumstances. So in specific circumstances, the regulators can also go after the data processor. Now, if that happens, that's fine, that's regulatory. The controller may still have a full suite of legal redress against the processor as well, be it contractual, be it under tort or other laws. And the individuals affected may also have a claim either against the controller or against the processor. It is likely that the processor will bear most of the responsibility because of the contractual requirements. And if the processor is a large enough standalone entity these days, regulators will look to them, I think, in the first instance, if they can show that it was their actions or inactions that are directly responsible for the breach.
Okay. So, I mean, we're all a little bit in this situation, right? Because we're both, having our own data that we have to communicate to others, and we hold data of the other people. We're all been in this data exchange. So, knowing all this, how do you manage all this liability? How do you even calculate all this liability that you could have within all these contracts and legal obligations?
Yeah, it's very challenging. I mean, trying to assess what the impact of a breach is, or an outage. You mentioned earlier CrowdStrike. 2-3 weeks ago, we had the CrowdStrike outage. That wasn't a breach, but the impact of it, because that led to an authorized access to data as people's systems went down, which itself could be deemed a breach of the laws. How do you quantify that? I think it's very, very difficult to quantify. The direct loss caused by something like CrowdStrike, probably minimal. The indirect loss of time, loss of resource management, getting systems repatched and updated, huge. So working out the liability is going to be incredibly challenging. And that's always the case. I mean, that's why a lot of organizations have looked to cyber insurance and tried to set the parameters around that, really trying to think, well, if we look at the scale of our business, what do we see the risk as being, and what insurance level would we want on that? And trying to position themselves to have coverage under cyber insurance instruments to ensure that they can, in the event of an attack, be covered for the liability of claims and those of their customers.
Yeah, it's funny you mentioned insurance. It's a great point, because a lot of insurance within their claims will have force majeure or things like this that could be claimed in the event of war. We've seen it with NotPetya. So how it's difficult to provision for insurance when that increasingly we're seeing more and more nation threat actors that can be considered active war. So do you have any tips on how you could review contracts and understand more about what's insured, what's not, and deal with risk this way?
Yeah, I mean, the cyber insurance market has evolved significantly in the last 2 or 3 years. I think in two specific ways. One, we have seen a definite narrowing of the coverage offered under cyber insurance policies. So as you rightly point out, acts of war, certain acts of terrorism, and the definitions within those have been narrowed. The fact that cyber insurance policies won't cover outages or non-threat actor breaches. So, for example, CrowdStrike, I know that quite a few organizations have been called out saying, well, actually, this was a patch update, rather than a targeted or non-targeted attack. So there's been a narrowing there. So it's critical that you understand exactly what the scope of coverage is. The other issue is premiums have obviously gone up. So then it's work trying to sort of do the balance of actually what level of cover do we get, and what is the sort of premium that we have to pay or deductible that we have to pay in order to cover ourselves. And how do we balance those two commercially? So I think that when you're looking now at any insurance contract, it's critical to have an understanding of what's in and what's out of scope. It will be narrower than it was previously. And again, then it becomes, as it does with any insurance policy, the same as when you insure your car. What will you accept? How much excess will you accept? Do you want third-party fire and theft, or do you want fully comprehensive? there's going to be a cost impact. And that's the same, a lot of these insurance instruments now are incredibly bespoke. So it will be about your position as well as to what you can negotiate to get the coverage that you need.
Yeah. It's something that needs very much studying and measuring, which is something you said that can be difficult to achieve. Speaking of difficulty, there seems to be a ton of, some have been sticking around, but more and more popping up. I've seen posts about DORA and everything, so it's stacking up. What do you think is the legislation that you've seen organizations struggle the most with?
So, when you talk of new legislation and what organizations are struggling with, I think DORA is a great example. Obviously, the Digital Operation Resilience Act, it applies to the financial services sector in Europe, and it's about trying to ensure that there is functional operational resilience for critical infrastructure and financial services within the digital society. So it's a really, conceptually, it's a very, very important piece of legislation. But as you look into the legislation, the requirements around governance, the requirements around reporting, the requirements around supply chain monitoring, right? And the idea that all of this is put into an organization's, or through an organization's lens of proportionality, and how, each organization themselves must assess their own situation, their own risk, and make their own determination as to how to apply the laws, I think has been quite challenging. Now, for DORA, we've got until the 17th of January next year before it takes effect. And we know that, there are a lot of organizations ramping up, trying to understand, what the right measures are for them and how to implement them. Then interestingly, like, for example, on the supply side, we're seeing providers trying to understand what their obligations will be and how they can reflect those in contracts. Basically saying, we will allow you X, Y, and Z, or we will require you to do X, Y, and Z. And putting this in a standard contract, which may then be used for customers in the US or customers in the UK who aren't subject to DORA, who are saying, hang on a minute, why am I now being asked to either do more or allow more? It doesn't affect me. But as we kind of saw with the GDPR, this idea of the Brussels effect, once it's in place, it's easier for organizations to manage globally in some instances than it is for them to start splitting up geographically or regionally and having different terms in different places. So I think for some organizations who aren't subject to DORA, they're suddenly seeing DORA-style clauses being put into contracts and things and questioning why. And I think educating and understanding, well, actually, that's going to be, that's just because you're now sort of, the bar's being raised and you'll have to meet it, is an important education piece. I think the internal programs are also being challenging, and we're going to see it now. We had the EU AI Act just come in. Obviously, we've got sort of delayed enforcement of that over the next 6, 12, 18, 24 months. But again, it will be that idea of understanding, evaluating, but doing it on a very subjective basis. So looking at what the law says objectively, and then looking at it through your very own personal lens and saying, hang on, but how should we be risk rating this? And again, it comes back to what we talked about. Document those decisions, document the rationale, think about, because everything will need to be sort of, I think, recorded as evidence later in case it's sort of called upon, so you can show how you developed your program, why you took the decisions you did.
Yeah, I think justification for taking risk or not taking risk is a key factor, because you might take a risk that might seem, let's say, silly or over risky, but then if you can explain why it's been taken and the measures you've taken against it, I mean, you're much better overall position just in general. I want to ask about another thing, which we talk a lot about the legal side, but there's a CISO as well who's in charge of the security, and there's a lot of overlap. So within organizations, what are some best practices that you've seen between the CISO and the law part of a company?
So CISOs, the role of the CISO and the role of the sort of legal function, to me, the two should be very closely aligned, especially in an incident response. They should be in clear communication. The incidents that or the clients that we work with who've had incidents, and the ones that we find that respond the best are the ones that have really well integrated programs. They've tested those programs potentially. They've done tabletop exercises or whatever. They've done crisis management before, but also each function knows its role, but is very well integrated. So there is clear communication at the top level, the CISO, the GC reporting directly to the board or the CEO to ensure that decisions are communicated quickly, clearly, and effectively at the point of crisis. But they've all got slightly different functions. The CISO will be in charge of the technical aspect, but the CISO should be aware of who their MDR provider is, who their forensic service provider should be. Should it be the same? Sometimes that will give you an efficiency, which is great. Other times you may think, hang on, is one organization marking its own homework here as it sort of goes through a crisis? Do we want somebody else? Yeah. But making sure your CISO is aware of those prior to any is fantastic. It will be the general counsel's position or the legal functions position to understand the regulatory requirements, to work with external counsel such as myself, and try and bring those elements together. And I think that those two, the CISO and the GC, are the ones that should be briefing the board or the C-suite. So the CFO, the CEO, to understand so that they are fully cognizant of what's happening at all times.
Mm-hmm. I see. We're talking about different profiles here. We have the CISO, the GC. There's a trend that's been happening that I've seen. It's that personal liability, so sometimes to the extent of criminal liability, are more and more applicable for cybersecurity cases. Is that true? Is that something you've been seeing?
Yeah, I mean, we've certainly seen it. We saw it in the US with the SolarWinds case. I think there's a case brought against the CISO in that instance, and he was found personally liable. If we look at the legislation that's coming through in Europe, there is definitely the ability for individuals, directors and officers of the company to be found personally liable. Now, it's interesting for the most part that a CISO is often not actually a director or officer of the company. It is a title of Chief Information Security Officer, but they're not actually in a position of board responsibility or an officer of the company. I think it is increasingly a risk for CISOs that there could be personal liability. And one of the challenges here is that it is the responsibility of the CISO to implement and oversee a security program. It is also their responsibility to develop that program and to ensure, because all cybersecurity programs are dynamic. Nothing stands still. What I built yesterday or last year will probably need updating this year, right? That is the nature of the business, way that we handle data, the way the technology moves on, the way the state-of-the-art security, and that threats increase. We have to react to those on a daily basis. So being able to do that and to flag what is required organizationally, financially, to management to say, this is what we need. So the execs say, this is the budget we need. These are the resources we need. And then to be able to implement on the back of those is a key function of the CISO.
And so when we talk about, just to define here, personal liability in real terms, what could that mean?
Well, personal liability can mean two things. It could either mean a financial sanction, or it could, in some instances, mean jail time.
Wow.
Yeah, I think that's likely to be at the most egregious, negligent, willful, or destructive end of the spectrum, where somebody has actively gone out and done something or admitted to do something on purpose. Yeah, and as far as I'm aware, nobody yet has been jailed on the personal liability front. Mm-hmm. Even being called out for it on a financial sanction, it is enough to try and put the fear of people taking on those roles. And those roles are critical to an organization, And I don't think there's any way of contracting out of the liability. It may be that your organization would, assist in covering any investigation or claims into you or any legal defense, but I don't think you can contract out of it at this point.
Yeah, perhaps. Yeah. So if you're a CISO and you're scared of this personal liability aspect, what are some recommendations one might apply in order to protect themselves against these possible personal liability claims from regulators or the company?
I think a CISO has to be both pragmatic and careful. And some of it comes this kind of thematically back to what we've been talking about, is documenting the position. Mm-hmm. Making clear in correspondence with those higher up the chain, with the legal department, what concerns and issues there are, right? And trying to act on those and continuing to press where they need to press. Again, if you can show an evidence that certain decisions and the reason behind decisions being made is financial, it was by the board, it was by a third party, rather than you as an individual, because you flagged those issues up, that will be helpful. Now, all of these issues go to mitigation. They don't remove liability. But I think if you can show you took steps that were reasonable and rational at all times to advise the company of where resources were needed, that's going to be an important point.
Yeah. And if the company effectively doesn't want to give you these resources, you can point back, hey, I've assisted, we've had this many meetings, you never give it to me. There should not be any pushbacks. If the board or the CEO is found responsible for not giving the correct budget to the CISO, could then the CEO or the board be liable personally for an incident?
I think it's very possible that anybody who's a director or officer of a company could be found liable. It doesn't have to just be the CISO. I think we have focused on the CISOs to date, and that's mainly from the cases that have come out of the US. But I do think it could quite easily be another executive. And there is an argument that within every organization, the buck stops with the CEO because they're the top of the food chain. They are the chief executive officer. They make the executive decisions. Everybody should be reporting into the CEO. So I think there is potential for that to happen. It's critical that not only those involved in cybersecurity are thinking about these issues, but actually they are educating those that they work with as officers, saying, look, this actually falls on all of us. And in thinking about these issues where I'm reporting to you, it could come with a personal liability to you as well, because that often gets forgotten, I think.
Yeah, for sure. Ultimately, someone has to be responsible. Rohan, we propose we do a little bit of a quick, fast this or that situation where you can answer yes, no, or whatever the question propers. Just quick answers, and then we'll discuss them. Are you ready?
Okay.
Great. So, shall all employees receive mandatory cybersecurity training by law?
Yes.
Who should bear more liability for data breach, the C-suite or the IT department?
The C-suite.
Should companies be liable for cybersecurity breaches caused by employees' mistakes?
Yes.
Who is liable for breaches caused by vendor software, the vendor or the user?
Vendor.
What should companies prioritize post-breach? Transparency with customers or fixing the issues?
Both.
Yeah, I agree. Should it be legal for companies to pay ransomware demands without penalties?
Was that illegal or legal?
Legal.
For the most part, it is legal. Payment of ransom is not illegal unless it's going to a sanctioned entity.
Okay, we'll get into that. And one more. After a cyber attack, should a company settle quickly or fight in court?
It does, fact specific, that one. I think you try and remediate quickly, but then look later as to what the legal implications are.
Okay, I see. Right, it makes sense now. Wow, it's such a new world for me, the whole legal part. So let's get into the ransomware demands. That you can totally pay the fine and you won't have repercussions. Is that what it means?
Yeah, look, it's got in most jurisdictions, the payment of a ransom is not illegal. It is never encouraged. And in the UK, the regulators, law enforcement have been very clear, including the Solicitors Regulatory Authority, saying that we should not be solicitors advising clients to pay ransoms. These are criminal acts, and they are criminals extorting money. However, that said, the payment, unless it is to a sanctioned entity, is not actually illegal. And some organizations, for whatever reason, and then there are a number of reasons, may think that it's actually more efficient to pay such a ransom than to not pay. And I think sometimes organizations do pay, because if they didn't, the business of ransomware and the threat actors that do these attacks would disappear. The fact that they are still going is because they're making money.
Mm-hmm. Yeah, totally makes sense. It's a great business, I've seen. It makes sense. Well, I've seen a recent breach where the cost was evaluated to be in the hundreds of millions of euros a day. So if you got a €6 million fine on our ransom, maybe if you only have a 15% chance of retrieving your data, you're going to try it.
The biggest issue is really not about paying a ransom. It's about thinking, why are you in a situation that you are considering you need to pay the ransom, right?
Tell me more
That
about
probably means you don't have the right backups. You don't have the right infrastructure security. So there's been traversal across the system, allowing for greater encryption of systems, or greater data exfiltration of more sensitive information. That goes to your compliance program way before the attack, right? And again, that's something to be thinking about when you're thinking, well, hang on, would we get in the position of needing to pay a ransom?
I see. Okay. Yeah. So we talked about personal liability as being a driver in decision making for individuals. Now, what if there's an individual within the company, let's say an accountant, that steals all the financial data of an important company and is selling it to other people, let's say for information for trading better at the stock market, which we know is illegal? How is personal liability involved there, and what kind of liability could the company face in such a situation?
Yeah, look, in that situation, the individual is a criminal, right?
Mm-hmm. Yeah.
What they've done is not in the course of their employment. But they have taken information during their employment and then acted independently in extracting that information and in selling that information. And I think we have good legal precedents, even to show that the individual, as soon as they start acting on their own, become an independent entity and take independent responsibility and criminal liability for that.
Mm-hmm.
However, and we have had cases where this has happened, in fact, where payroll lists and employee lists have been taken, right? That the employees affected have then been able to sue their employer to say, hang on, even before the individual extracted that data, how were they given access to that data? Were the right protections in place? So you have to look at this on an almost phased basis. Was the internal compliance program robust enough and accurate that, in fact, the criminal couldn't have been stopped from acting? Or was it lax? So, in fact, the criminal could do whatever they want because nobody actually ever logged what data they were looking at, which is why they were able to extract it without anybody noticing and sell it. So there will be different points that we'll look at to see where liability vests. Now, it may be that the organization gets some liability, but it won't get total liability or anything, because as soon as the employee moves into that realm of independent acting and criminality, they, I think, create their own liability bubble around themselves.
Mm-hmm. Right. But isn't that a bit unfair then? Because there's, if it comes to a ransomware group, that it's almost less forgiving than if it's an employee, right? Because an employee, you can always pass on the blame to a person. While for government, it'd be very hard to pin down a ransomware group who's likely not even in the country there are. So isn't it a bit unfair to corporations, the risk? Do you understand what I mean?
I'm slightly confused. So if I've got look, the fact is, in both scenarios, the organization, the employing organization, is the victim of a crime. One is done by a criminal that may be international and harder to identify, but were they identifiable and were they arrestable, there would be a clear criminal precedent for arresting them. The fact that an individual employee can be identified and arrested, I think, is helpful. Now, in both instances, the affected employees would still have the same claim against the organization, right? And then the same assessment, I think, would be done of the organization's compliance program and its cybersecurity program to understand, were there the correct logs in place? Was there the correct multi-factor authentication or anything else that could have prevented the issue from happening in the first place? And if the answer is no, we had really good, we were like Fort Knox, but somebody still managed to get in, then it's likely there would be very little action against the organization. If it's, we left all the windows and doors open so any employee or any third party could come in and take what they needed and we wouldn't know about it, then it's likely the organization will have a bigger challenge.
Of course, yeah, makes sense. I mean, we go back to this idea of showing. So if we go back to this podcast a bit, recap a bit what we've seen the importance of documenting, of showing the reasons why you take different decisions, cybersecurity decisions. We've seen the importance of understanding your context, right? Understanding your suppliers, third parties, the liability you might face, measuring the risk. Rohan, do you have any other tips that you think are relevant in terms of cybersecurity plus legal aspects for CISOs or executives to follow?
Yeah, I think with regard to the steps that CISOs and legals, other sort of C-suite executives should be following with regard to cybersecurity programs, I think you're right. It's think early and think fast. Take into account who we are and what we do, what data we have and how we process it, what resources we have, and what the state of the art out there that we could employ. Think about technology. Think about organizational measures, because they're going to be critical. And I think then, do tabletop tests, do exercises. Nothing prepares an organization for the real thing, better than a test, other than the real thing. And if you're learning on the real thing, you're going to be wasting valuable time. So, know who your forensic providers are, know who your external legal counsel will be. Think about, where the jurisdictions you operate, the laws under which you operate, what types of notifications may be required in those first 72 hours. Because when and if an event happens, it will be time critical that you can respond. And as you're working through, the more familiarity you have, the more efficient you will be, the better your response will be, the greater your mitigation will then be in the event of any regulatory sort of investigation or enforcement.
Well, makes a lot of sense. Yeah, preparation. Great. Rohan, if people want to hear more about you or your company, where should they go?
They can find me at ropesandgray.com, where we have a website along with a blog on all things data and podcasts on all things data as well. So please do come and visit.
Great. Thank you so much, Rohan.
Matt, good to see you. Thanks again.